welcome everyone back, and welcome to those who've just joined us, where we're going to hear from our presenters talking about neurodiversity in the courtroom in this session. I am Miranda Morgan. I'm one of the founding members for the Institute of Neurodiversity, and I'm going to be your moderator for this session. So I'd like to introduce the first of our four presenters. So welcome to Professor Penny Cooper. Penny was called to the bar in 1990 and moved into academia in 2002. She devised the English model of the witness intermediary and the ground rules herein, setting the parameters for the fair treatment of witnesses, and the Advocate's Gateway, the premier international source of guidance on vulnerable witnesses. She has led the Advocate's Gateway since inception in 2002. And Penny has been the principal investigator, co-investigator on numerous grant-funded projects, of all which explore and promote the effective and participation of witnesses, including experts in courts and tribunals. Penny is a visiting professor and senior research fellow at the Institute of Crime and Justice Policy Research, Brookbank Law School. She was an Associate Dean of City Law School for 10 years and a Professor of Law since 2009. She's also former Governor of EWI. Penny has authored and co-authored over 150 published pieces, including leading Oxford University Press book, Vulnerable People and the Criminal Justice System, by Cooper and Norton, 2017. Alongside her academic role, she is a consultant specializing in witness familiarization for numerous international commercial law firms. So welcome, Penny, and over to you.
Oh, thank you, Miranda. And I'm sorry that I've written so much spiel about myself somewhere that you've managed to find on the internet. But I suppose a short introduction, if I'd been doing it, and thank you very much for that very generous one, is I'd just say I'm really interested in the participation of people in courts and tribunals. And that's been a theme throughout my career, even before I started research in the area. I just want to, help people do it a bit better when they're witnesses or if they're interviewing witnesses. And what I want to talk about this afternoon is a very practical tool, the ground rules hearing. But when I talk about it, you will hear mention of a couple of things that tie in that we've heard Kim talk about. We've heard Katie Maris, who was on just before me, mention intermediaries and also the Advocate's Gateway. And I'm going to hopefully just show how they all fit together for those of you who might not be sure. And also leave everyone with a message about how essential ground rules hearings are. They're not complicated, it's not rocket science, but thank goodness they've taken hold, really. They've got a grip on the justice system and they seem like they're here to stay. The first thing that I wanted to do is talk about the language of the justice system and therefore the courtroom, because although I've been tasked with talking about something in the context of a conference on neurodiversity, neurodiversity is not a word that you hear very often. Well, I don't think I've ever heard it at all in the courtroom. It probably does get mentioned now and again. But what you hear often is the word vulnerable related to witnesses or to an accused person or a party in a case. That is the common currency really now if we're talking about adjustments for people who have, amongst a whole range of things, but neurodiversity being one of them, if it's affecting their communication, with the whole purpose being from the lawyer's point of view of ensuring effective participation of people who are being a witness or a party or a defendant in a case. And if you are trying to exact some sort of change really in the justice system and in the courtroom in particular, you have to recognise the environment in which you're working, of course, which is legislation and case law. So things that Parliament have said about how a courtroom should run, case law, so when the Court of Appeal or higher, the Supreme Court has said how a court should run. And then the procedural rules, which are, just as the name suggests, very specific guidelines that say step by step, this is what should happen, and this is the order it should happen in. overall, in any particular courtroom, a judge is going to decide what's fair in the context of that law, that legislation, case law, and those rules. It is the judge's responsibility, and these days it's a more recent thing, but we hear a lot of talk about the overriding objective. If you're in a courtroom, you might hear lawyers and judges referring to this, and really all that means in a nutshell is the objective is to run a fair hearing. Vulnerability in the courtroom can mean, for example, that somebody isn't even fit to stand trial, so it can affect capacity. But when we have a lot of adjustments in the courtroom, it's because it's been decided that somebody does have the capacity to stand trial. And if it's in the case of witnesses, that they have the competence to be witnesses. The test for competence is quite a low hurdle to get over for a witness. It's basically that you can understand the questions that are put to you and you can give answers that are understood back. But as was said by a former Lord Chief Justice in the Court of Appeal, that doesn't mean every question. In other words, you don't have to pass a test that says you understand every question and every answer that you give back is understood. Because, as he said, that former Lord Chief Justice, a lot of witnesses would fail that, whether they're vulnerable or not. So assuming somebody, if they're an accused person, is fit to stand trial, if it's a witness, if they're fit to understand questions and give answers back that are understood, what sort of adjustments does the law say you can apply to support communication? If your neurodiverse witness would need to fit into one of these definitions in order to be able to access what are called special measures. That's the terminology, the common currency that's used in this sort of context when people are talking about adjustments. So the vulnerable witness is gateway to special measures as set out in the Youth Justice and Criminal Evidence Act, is that they're either under 18 or the quality of their evidence is likely to be diminished because, and you can see that on the slide, and these are going to be available afterwards, they suffer from a mental disorder within the meaning of the Mental Health Act, or otherwise have a significant impairment of intelligence and social functioning, or that witness has a physical disability or is suffering from a physical disorder. It's quite complicated, really, on the face of it. There are many judges that you would speak to who'd say, can we not just have a simple test that says, I will determine whether or not it's fair to make those adjustments? But we're at the moment we're working in the criminal justice system, at least under the legislation that's fairly old and over 20 years old and a bit more complicated than it has to be. But I think generally speaking, though, it does work well, and judges will make orders or directions more specifically for special measures when they're needed. The trouble is, that all sounds very good, doesn't it? The trouble is, and I've said it, people have said it before me, people have said it for years, it's been said more recently by the Criminal Justice Inspectorate in their report in 2021, we need to be able to effectively screen for neurodiversity. That means the police, that means lawyers, that means court staff. We haven't got, you've heard this already today, we haven't got a standard tested screening tool for neurodiversity, or indeed more generally for communication disorders. So I've known of cases, and probably many of you who are attending today will be aware of cases where you just look back and you think, well, it was lucky it was picked up. It was lucky that that police officer, for example, had a nephew with autism, and they spotted some sign and made them think, actually, we need to test to see if there is some sort of potential communication barrier here. And you might think to yourself, well, why don't we just get on with a screening tool and sort that out? I think it's partly because we don't have that solid evidence to say this is the degree to which there's a problem, because there's no reliable, as the inspectorate said, no reliable, consistent or systematic data collection to tell us about the extent of neurodiversity. So that is another big problem, and a recommendation of the report, among as well as screening, was that got addressed to. Anyway, if it is identified, then the lawyer whose witness it is or whose defendant it is needs to apply to the judge for special measures, otherwise known as adjustments or adaptations for that particular person. And what questions will be asked? Well, things like, is there a diagnosis, and then beyond that, and what is the impact of that diagnosis, and how in particular is this information relevant to the courtroom? So is it going to impact on how often we have breaks, for example, how the lawyers communicate with each other, where the accused sits, where the witness gives their evidence from? All of that should be looked at. The starting point is actually special measures. These were set down in legislation, but as I say, they're a starting point. There are lots of other measures, which I would call extra special measures, which can be applied for, and judges can and do direct if there's a suitable evidence base to show that it will improve the quality of the witness's evidence or participation. So live link, giving evidence from another part of the courtroom. In some instances, there are places in certain parts of the country, I'm talking about England and Wales here, there are places where you can go to give evidence when it's not actually the courtroom. So it might be in a different part of town, for example. You never actually have to walk into the courtroom, and that can be a really good thing if you want to ensure that that witness, for example, doesn't run into the accused if they're not in custody, or the accused family even. Screening the witness from the accused. So that would be when a witness says, for example, I don't want to see them, or I don't want them to see me. So you can put up screening systems, not that they are all as good as each other. In some courts, you literally have old-fashioned screens like you might have in a hospital, sort of folding screens with material in them. In other courts, you'll have a purpose-built rail around the witness box that you can pull a curtain around, so the judge and counsel could still see the witness and the jury if it's a jury case, but the accused can't. Pre-recorded evidence. In the last few years, we've seen that rolled out over the country for certain witnesses, that they can go to court and be filmed being cross-examined and never actually have to go to court for the trial. For many years, we've had people recorded in interview. You heard Katie talk about AB, achieving best evidence interviews, and those played at court. But up until the last few years, it was still necessary for that witness, even though they'd recorded their account, to go to court and be cross-examined. Well, I'm really pleased to say some witnesses never have to go and step into the arena of the actual trial. It's done beforehand in the absence of a jury. Removal of wigs and gowns, that's fairly uncontroversial special measure. Evidence in private, not used very much as far as I'm aware, but the court can, the judge can decide that they're going to be limited number of people in the courtroom. Limit it, for example, to everybody out apart from the essential people, the representatives, and perhaps one representative of the press if the press are there. And then we've got intermediaries and communication aids. And intermediaries, they've been around since 2003, since I trained the first intermediaries for the Ministry of Justice. They came to me, the Ministry of Justice, when I was relatively new in academia, and they were looking to engage an organisation. I was at City Law School at the time, part of the University of London now. They engaged my department, which was me and a part-time person at the time, and soon recruited some other people to help, to provide training for intermediaries, a professional, usually speech and language therapists, but not always, psychologists, teachers, occupational therapists, and so on, who would come in and assess witnesses and advise the advocates in the case, or the barristers mainly, advise them how to properly communicate with that particular witness. So all designed with the purpose of reducing the barriers to victims and witnesses giving evidence. So I came up with this idea for a way to train them and a way for them to operate. And one of the ways in the early days that I suggested that they operated was producing a report with a section at the back to make it an easy read for lawyers, because we all know, they, including me, get your report for an expert or a lengthy report from a medical person, for example, and you go to the back, look to the conclusion. So I said, put a section in the back called ground rules and put it in a table, make it an easily accessible guide, and then discuss it with the lawyers before cross-examination takes place. And hey presto, all will be well. Or so we thought. I was a little bit naive because I was conducting research with intermediaries once it started out in practice, and they were saying, well, we would agree things with the barristers before the cross-examination started, so outside the doors of the court, and then when cross-examination came along, they wouldn't be following what the intermediary thought had been agreed. So along with my colleague David Wurtzel, when this information was coming back to us, we said, well, you need to get this in front of the judge, and you need to get the judge's stamp of approval on these ground rules, because judge is in charge, and if the judge says this has got to happen, then you've got much better chance that the barristers will do it. So those very early days of the intermediary scheme involved intermediaries trying to get into court for meetings or hearings, ground rules meetings or ground rules hearings with the judge, and sometimes facing real difficulties, like court staff saying, oh no, you don't come into court, and some judges even were saying, oh, I don't have meetings in my court. But we got over that hurdle, or particularly I should say the intermediaries did, and I was encouraging them and publishing research on ground rules hearings at the time. And to cut a long story short, ground rules hearings stuck, and they ended up getting written into some guidance and some rules, more of which I'll tell you about in just a moment. Communication aids are also a special measure. There's a great toolkit which Dr. Michelle Mattison was the lead author of. She whose research was mentioned just a short while ago by Katie Maras, sketching to remember interviews with people with autism. That paper's worth a look, but so is this, the toolkit that she led when it came to pulling together all the information that we thought would be useful on the Advocates Gateway for barristers to show how communication aids, and here's just one example, could really support people to give their evidence. And it doesn't just mean in interviews, it means actually in the courtroom or the live link room. If they're giving evidence over the video, it's regarded as an extension of the courtroom. They could end up with an intermediary on hand sitting next to them using wooden dolls to explain, for example, if there was, let's say, a fight, if they'd been assaulted, how that occurred and what happened, using dolls to support their communication. That's just one example of the communication aids toolkit, talking about a deaf defendant who was able to act out an action scene during his evidence using these artists' figures. These sorts of things, these communication aids, are frankly very unlikely to get used unless you've got an intermediary, because you need somebody who has tested them out with the witness and can explain to the court not only that they work, but how they work. And all of this needs to happen at a ground rules hearing. So what you don't do is you don't say, oh yes, we've got a witness here and we've got an intermediary, let's see how we get on. The intermediary can just intervene if they need to. No, you get together beforehand, as I said, intermediary, barristers in the case, and the judge, and sort it all out as best you can, with the hope that the intermediary doesn't have to intervene at all because the parameters have been appropriately set. One way of looking at it is one way of looking at it is measures directed by a trial judge to protect a vulnerable witness without impacting adversely on the right of the accused to a fair trial. They popped up this phrase, ground rules hearings, in 2013 in the practice direction. So that's guidance, not quite as strong and impactful as rules. I sent off some research to the Criminal Procedure Rule Committee, and after a little while got a message back from the secretary to the committee that almost made me fall off my chair and also dance a jig simultaneously, to say we're going to write ground rules hearings into the criminal procedure rules. Here's our draft. Have you got any advice? Does this look all right? It was such a relief. It gave intermediaries in particular something to say, you know, here, this is what I'm talking about, ground rules hearings, and it's actually in the criminal procedure rules saying there should be one, and there should be one in any case where there is an intermediary. We've moved on now really to a position of accepting that there should be, and I'm talking generally amongst people who are up to date in the justice system, not just in crime, but we've moved on to a position of accepting that where there is any vulnerability in a witness, in any type of court or tribunal, there should be a ground rules hearing. Just get it straight before the evidence starts, what exactly it is we need to do to support this person to give their best evidence. As I say, all within the context of ensuring that there is a fair hearing. There's no legislation about ground rules hearings. That would be the best thing, the strongest form of law. If Parliament said ground rules hearings should take place in certain circumstances. It has happened in Scotland quite recently. Some new legislation about child witnesses and ground rules got written into that. But even before that, actually got written into legislation in Australia and a couple of different states there. And what brought it about in Australia was the introduction of intermediaries there. And I went over in 2016 because the idea of intermediaries has, the practice of intermediaries, I should say, not the idea, has been so successful in this country. New South Wales was the first one to get in touch. Their Attorney General came over, I think it must have been 2015, interested to see what more could be done to support witnesses, said, okay, yeah, I like what I hear about intermediaries. And I went over in 2016, supported by Dr. Matheson, to provide training and get it started there in New South Wales. And there are a number of other states that have intermediaries now and ground rules hearings. So they've really been quite a good export. By the by, the idea of the intermediary came from Western Australia in the first place many years ago, even though they'd never used them very much. It was an idea that we liked over here, and that's how it got written into our legislation. So there's something quite nice and circular about intermediaries coming from Australia as an idea, getting implemented here in a certain way, it being successful, and then travelling all the way back to Australia and being and spreading out across the different states over there. If you want to read a bit more about the history of ground rules hearings and when they work well and sometimes when they don't work well, have a look at that article. It's freely available via that link. The Vice President of the Court of Appeal, no less, for the Criminal Division, said this: judges are taught in accordance with the criminal practice directions that it's best practice to hold hearings in advance of the trial to ensure the smooth running of the trial, to give any special measures, directions, and set the ground rules for the treatment of the vulnerable witness. We expect a ground rules hearing in every case involving a vulnerable witness, save in very exceptional circumstances. I haven't really got my head around what would be very exceptional circumstances. I suppose there's always an exception to anything if you think hard enough. So that's basically the rule, though. Ground rules hearing if you've got a vulnerable witness. And there is some very useful reading in what's called the Equal Treatment Bench Book, ETBB. It's quite a big book now. It's written by judges with advice from experts, and it's all about, well, as the name suggests, being aware of people's differences, not just differences in neurodiversity, but cultural differences and so on. And what they say about ground rules hearings there is that they're mandatory in all trials using intermediaries. They remain vital even where participants have worked with an intermediary, as arrangements need to be agreed that are specific to the individual before the court. The intermediary must be present but need not take the oath. So let's not turn an intermediary into a witness, I think they're saying there, and start cross-examining them. Let's work with them. And just because you've had a chat with the intermediary before and you think you've got it all straight in your head, no, have a hearing with the judge. They are being used in family courts, they're being used in tribunals. It's not just the special measures that get talked about in ground rules hearings. It's any and all things that intermediaries have concluded will support the witness to give their best evidence. And these are maybe quite rare in some instances, but I want to just give an indication of the variety of things that intermediaries have come up with to support witnesses to give their best evidence. So tents for very young children, so they have a place to go to become more emotionally regulated in a break, a tent in the live link room, or a rocking horse outside, or even in the live link room for them to go to breaks. We've had dogs and cats being with witnesses and accused people to help them help decrease their anxiety while they're giving evidence or taking part for the accused in the trial. Fidget toys, timelines, so visual timelines, so help people when they're being questioned about something, orientate themselves in time. Anxiety scales, so they can indicate to an intermediary if they're getting to a point where they really need to have a break because their anxiety is impairing their ability to participate. Equal treatment bench book. Do have a look at that. I'm going to skip through this because you can read through that if you're particularly interested in ground rules here to get more of a, it goes wider than rules. It gives you lots of sort of practical examples of ground rules. Okay, you know, it's a bit like I was saying earlier about the legislation. It's all fine and good, isn't it? And what I've told you now is all fine and good, but the real pinch point, just in the last few minutes that I've got, I want to talk about, and that pinch point is cross-examination, because generally speaking, the psychology will tell us, you know, to get the most complete, accurate, coherent evidence from a witness, which is what you'd hope we're trying to get, requires you to build rapport and ask open questions, you know, subject to caveats that we've heard about from Katie for witnesses with autism. Cross-examiners, though, are wary of open questions because they don't want to lose control. They don't necessarily know what the witness is going to say. They don't want to build rapport because they're on the other side. They're putting an opposite version of the facts. And fundamentally, they don't really want the best quality evidence. They want to be able to say in their submissions at the end of the case, well, you heard from that witness and their evidence is unreliable for the following reasons. So there is a tension there, but it has to be sorted out by the judge at a ground rules hearing. The Equal Treatment Benchbook gives some suggestions for the sorts of things that should be said to advocates at a ground rules hearing so that they prepare appropriately, plan their questions. Pronouns should not be used, for example. Questions should be simple and contain only one matter. There should be no directive leading questions, which are both coercive and unnecessarily complex. Generally speaking, these things look fine, but you need witness-specific advice, which is where the intermediary comes in, if possible. So I think, as I say, the Equal Treatment Benchbook's got really good stuff, and some of the training that advocates go on is basically good, but with the caveat that it may not be exactly right for that particular witness. I've just highlighted there some studies, mainly with criminal practitioners, which tell us that generally actually people find it quite hard to ask open questions. We do tend to revert to closed questions quite easily as questioners. And of course, cross-examiners in the courtroom will revert to those very easily, because when we are taught cross-examination as barristers, we are taught to tell the witness, not ask them, to lead, and avoid ever giving the witness a chance to explain. Courtroom entitlements. I think if you're in a position and you are looking out for someone with a condition that makes them neurodiverse, then what you want to do is, certainly as a lawyer or anybody else for that matter, is be sure about what legislation is in place. Have a look at what the procedure rules say. Are there any practice directions? Have a look at the guidance. I know it's rather a lot, but pull it all together and see what's already there as part of the culture of the courtroom, because I can say it has changed a lot in the last 20 years, largely thanks to intermediaries and because of some powerful judgments from the Court of Appeal, like the one in 2014 that said advocates now have to adjust for the witness, not the other way around. I've included in my slide, and I'm going to stop now, a couple of free resources. I've done a video recently on communication and participation, working with Voiceability, which is a charity for people with autism and learning disability, trying to get across some points to improve communication between lawyers and people with autism and learning disability. There's papers that are open access, and there's a whole book on participation, and you can see the many different views that lawyers and judges have about what effective participation is. It's a bit of an eye-opener. I will stop there. I've had my full half an hour, haven't I? It's 42.
You have, and that's some very interesting and insightful reflections from you, Professor Cooper. We've got one or two questions that we'll take just before we move on. So I've got a question here about, what about vulnerable defendants in a traffic case, for example?
In a traffic case? Well, the traffic case tells me it's likely to be in the magistrate's court, rather than, unless we're talking about something serious like death by dangerous driving. Most traffic cases are in the magistrate's court. This guidance and legislation applies just as much to the magistrates as it does to judges in the Crown Court. And the accused, we've come round to accepting that the accused needs to have adjustments as well. It's not true to say that the legislation treats them the same as witnesses, unfortunately. They've been specifically excluded from most of the special measures. However, judges, I'm including that magistrates, can, using their inherent powers to ensure a fair trial, order whatever is justified for an accused person. It wasn't baked into the legislation, sadly. It should have been, but it was a political move at the time when special measures came in to rebalance the justice system in favour of victims and witnesses. That doesn't mean that there shouldn't be adjustments for the accused.
And just one more, is ground rules hearing a new term for case management hearing?
Is it a new term for a case?
Management hearing?
No, it's an aspect of case management. It's a new vehicle for case management, but it's not the same thing as a case management hearing. It might get rolled up into a case management hearing, but it's not the same thing.
That's fantastic, and thank you so much for your presentation. And as a neurodivergent person myself, I've experienced the tribunal court to completely fail in providing an inclusive environment and provide appropriate reasonable adjustments. But that's another story. So thank you so much. We're going to move on to Professor Warren Brookbank, who I believe is going to introduce himself.
Yes, I am here, Miranda.
Hello and welcome.
Thank you very much. I did send my slides to Beth, and she said that somebody would be able, perhaps you, to click on each new slide, because I'm not able to operate them from my location. So yes, there they are. So if you could if you could just move on when I give you give you directions. But it's a great privilege to be presenting at this conference, and I have to say I'm rather awed by the presentations I've heard so far. There's some wonderful material that's given me great pause for thought in terms of how these ideas might be developed in New Zealand. One matter that interested me greatly was Dr. Andrea Lalini's talk, where he talked about language-based learning disabilities, LLDs. And I have an LLD. I thought it meant Doctor of Laws. And then I discovered that it's actually learning-based disability. And then when I found that I met all the markers, I was completely derailed. So it's been a steep learning curve. But the talk I want to give today is on neurodiversity and the criminal justice system. So perhaps you could just move to the third slide, Miranda. And I just wanted to make a brief comment about distinguishing neurodiversity and neurodisability, because neurodiversity, it strikes me as a more benign notion of neural ability or difference, whereas neurodisability seems to be a more pejorative description. And certainly in New Zealand, neurodisability tends to be the term which is used. In fact, neurodiversity is not commonly used in New Zealand at the present time, although I think that's changing. But in any event, what I want to talk about today is an aspect of neurodisability that has already been addressed, and that's the issue of fetal alcohol syndrome. Because this particular neurodisability is a matter which has come before the courts in New Zealand frequently on recent occasions, and it's a matter of great concern. It's not something which is subject to legislation. By its very nature, it's hidden, and it means that there are probably many people within the criminal justice system with this condition whose needs are simply not diagnosed, and so there's a great potential for injustice. So I want to work through some general comments about the way in which fetal alcohol syndrome is a problem in New Zealand, and then look at a couple of cases where the issue has arisen before talking at the end about the idea I have for a presumption in favour of treatment for people with disability. So I could move to the next slide. The whole issue of neurodisability is something which has arisen really relatively recently in New Zealand. Indeed, Dr. Valerie McGinn, who is the leading neuropsychologist in New Zealand, who has done a huge amount of work around fetal alcohol syndrome, only became aware of this condition, as I understand it from her writings, in the year 2008. And she has given evidence in many leading cases in New Zealand, and as I'll talk about shortly, gave evidence before the Privy Council in the case of Tēnā Pōra, which led to Tēnā Pōra's convictions being overturned. But the point is, it's a very recent development in New Zealand, and in New Zealand in particular, interest has grown as we have begun to become aware more of the fact that within juveniles in particular, the brain development is often very protracted. As we know, often the brain in young males at least is not fully developed until they're often in their early 20s. And of course, in the context of youth offending, much youth offending occurs while the juvenile brain is undeveloped, which has significant implications for issues around responsibility and culpability when we're wanting to assign blame within the criminal justice system. The New Zealand Ministry of Health is now well aware of the problem and estimates that in this country, 1 to 3 in every 100 live births may be affected by alcohol. Alcohol is a well-attested social lubricant in this country, and particularly amongst our Indigenous Maori population, there is a very high incidence of FASD. And so the consequences of that are huge in the sense of loss of productivity, the cost to the criminal justice system, and with more and more young people coming into the system with fetal alcohol issues, the problems for management and treatment are highly significant. And as I noted, the last point on that slide, the referrals to the FASD Centre in Aotearoa, New Zealand, which was established, I think, by Valerie McGinn, 60% of the referrals were Maori. So it's a significant social problem for New Zealand that we are working hard to address. Next slide, please. There's been some very good presentations, so I'm not going to elaborate on points that have already been made, but just to make the point that alcohol is a neurotoxin and a powerful teratogene that has a major impact on the developing brain. And the point, which is often not understood, is that where a fetus is affected by alcohol, because the alcohol goes across the placental barrier straight to the brain, damages the brain, that is a lifelong condition. And it means, of course, that children who have been affected by alcohol while they are developing, it affects their growth in so many ways from then on for the rest of their lives. And not everybody, of course, who drinks while pregnant will be a cause of fetal alcohol syndrome. But where it does happen, the sufferer, of course, has many, many impacts in so many areas of their lives, which I've listed there, including motor skills, physical skills, learning, memory, and so forth. But the important point is, of course, that it is a lifelong condition, and it may have serious outcomes in mental health. There's a great deal of comorbidity between mental health disorders and fetal alcohol syndrome. And together with other conditions like ADHD and so forth. Next slide, please. This simply identifies some of the common neurobehavioral symptoms that the FASD sufferers may experience. There are many others, but typically social immaturity, which of course is a great vulnerability because it means that people don't understand social cues and may be led into antisocial behavior. It's also associated with a measure of egocentricity and particularly impulsivity, which of course is a significant problem in relation to criminal offending. And one of the cases I'll mention shortly illustrates this problem in particular, and a predisposal to inappropriate behavior, particularly when the young person is being led by other more sophisticated offenders. Next slide, please. So as I mentioned before, it's overrepresented in our Indigenous population, and this is not unusual. The Canadian studies show that there's a very strong correlation between racial discrimination and FASD amongst First Nations people, who are much more likely to have incidents with the criminal justice system or to be charged with a crime. What's interesting, however, is that at this stage in New Zealand, there are mixed views amongst justice professionals concerning what they understand or believe about fetal alcohol syndrome. And there are a number of cases where the issue has arisen, but it has never been developed or acknowledged as a serious concern. And although I think it's true to say that there is a much greater understanding and awareness of the problems, it's taken some time in developing. There is at the moment a major investigation being undertaken to determine what New Zealand judges know or understand about FASD in order to be better prepared in dealing with cases that come before the courts. Next slide, please. One of the areas, this is an area which is particular interest to me, is fetal alcohol syndrome and its relationship to unfitness to stand trial, which has already been touched on, and Penny Cooper briefly addressed that in her presentation. And the problem is that there is still quite a lot of ambiguity amongst New Zealand judges, as I mentioned, as to the status and relevance of FASD. And these issues particularly arise in cases where unfitness to stand trial may be an issue, and in New Zealand, because many sufferers don't meet the threshold for an intellectual disability under New Zealand legislation, often because their intellectual capacity may be above the threshold for intellectual disability. There is a perception, perhaps, that FASD is not relevant in determining fitness to stand trial. So cases go under the radar and the problem is not addressed. Next slide, please. Taylor Pora's case, the leading case in New Zealand, he was convicted of rape and murder in 1994, found guilty again at a retrial. There was a Privy Council appeal that overturned his conviction on the grounds that his confessions to the serious murder were unreliable because of confabulation. And what turned the tables at the Privy Council was Dr. Valerie McGinn's evidence that Pora had suffered from permanent brain impairment caused by undiagnosed FASD. Fitness to stand trial was not assessed at the original trial, and that may have been determinative of a different outcome. The case has been celebrated in New Zealand as the worst miscarriage of justice in the New Zealand legal history. And a couple of years ago, he received substantial compensation for the miscarriage of justice, but it's certainly a celebrated case here. Next slide, please. The next case that I wanted to briefly mention is Police in Morrison, a recent decision where the defendant had faced multiple charges of theft and assault, had a 24-page criminal history, but it wasn't until 2019 that his FASD was identified. And as the court noted, in the intervening years, over $2 million had been spent on prosecuting and imprisoning him for petty crimes. And the case is a very interesting case because the judge has taken the point to burrow down into what FASD means and all its implications. And it makes quite sad reading as the understandings are applied to this young man who eventually was sentenced to 9 months intensive supervision. He had a co-occurring intellectual disability, but sadly died just a couple of weeks ago before receiving any disability support services. So he's become a poster boy for how the system doesn't work for people with FASD. Next slide, please. The other final case I wanted to mention is the case of Hanara. This is a case currently on appeal before the New Zealand Court of Appeal. A vicious assault resulting in the victim's death, the offender was only 14 at the time of the homicide, sentenced to life imprisonment for murder. The court acknowledged there was a mental impairment on the basis of ADHD, intellectual disability, and alcohol-related neurodevelopmental disorder, but there was no mention of FASD as such. The psychologist report concluded that Hanara was of modest intelligence. Next slide, please. His overall cognitive profile doesn't appear to reflect permanent cognitive impairment. Now, I've moved to the next slide. This case has become a very, very highly contested case. There's a lot of interest in it. The appeal, I don't know whether it's been heard yet, but the issues it's going to address include the fact that although he had FASD, there was no evidence that the condition was adduced at the trial. There was an inadequacy of previous assessments of unfitness to stand trial. The question of his legal representation has been raised on the appeal, and more importantly, failure to consider the degree of brain damage and immaturity in the light of his age, 14 at the time of offending. And that means, of course, that if he was 14 at the time of the offending, that was his chronological age, his correct behavioural age was probably more like 11. So the case and its outcome is going to be attended with a great deal of interest. Next slide, please. I wanted to just finish by briefly mentioning something that I've raised in earlier presentations at a conference I gave, a paper I gave at a law and psychiatry conference in Melbourne some years ago. I raised the idea that because fetal alcohol syndrome is a justice issue, there is a need for some reciprocity. And I think equity for offenders who have a disabling condition, which simply is not their fault. They have simply acquired this thing through, of course, the actions of their mother drinking while they were in utero. The idea of a presumption is simply that we create a direction to the courts to follow a particular course of action, unless that's countermanded by necessity. And my suggestion is that the acknowledgement of fetal alcohol syndrome by the court ensures that a particular type of penalty and obviously imprisonment is not imposed. So it's a qualitative concern. And next slide, please. The purpose of the presumption would be to favour the need for treatment over other appropriate interventions exclusive of custodial sentence, so that once it was identified, and this will often be in the sentencing phase, once the court was aware of the disability, then the presumption would kick in and the court would have to find an alternative disposition that did not involve loss of liberty but focused on treatment, for the obvious reason that with people with fetal alcohol syndrome, punishment in the traditional sense simply doesn't work. Deterrence doesn't work. Retribution is irrelevant because of their cognitive and other behavioural deficits. And so the focus should be on identifying their needs, supporting them, and recognising the disabling effects of their condition, and ensuring that supports are around that person going forward to assist them with finding employment, so forth, and beginning to lead a pro-social life. The idea of having a statutory presumption is not new. New Zealand had many years ago had a statutory presumption in favour of non-imprisonment for property offences. That was unfortunately written out of our legislation some years ago, but it did work. And I suggest that this would be one way of assisting and acknowledging the seriousness of fetal alcohol syndrome for offenders coming into the criminal justice system. So thank you, Miranda. I'll stop there because I think I've probably gone over my time, but happy to deal with any questions. I think you're muted.
Thank you so much. Sorry, I've lost my connection there for a moment. Really fascinating presentation, and something I resonate with as a social worker myself. I've kind of worked with mothers and where their babies have been born and later gone on to be diagnosed with fetal alcohol syndrome, and I know the process for diagnosis is quite complex and difficult. but some great examples that you've given, but also some very sad cases that you've raised as well, and also how the system is failing children, young people and adults who have fetal alcohol syndrome. But fantastic presentation. I don't think there's any questions in the chat, so I will
wants to communicate with me. I've given my email address so they can write to me.
Yeah, and there's also there's a lot of chat around what you've said. There's people have posted a lot of information, a lot of links to studies, and kind of looks very fascinating in terms of what people are saying. So if I can guide people to have a look in the chat room for further information. So that's excellent. Fantastic. Thank you so much. Thank you. I think we're going to move on to Melanie Jameson. She has 30 years experience as a neurodiverse specialist. This includes posts of special advisor to neurodiversity charities and briefings on dyslexia and offending for UK House of Lords debates. She has undertaken committee work within a number of government departments, most recently the Ministry of Justice Practice Development Group for Learning Disabilities and Pacific Learning Difficulties. She's written on dyslexia, neurodiversity and the justice system in a range of publications, such as the Magistrate and Probation newsletters. In 2008, she was commissioned to provide guidelines on neurodiversity for the Judiciary Equal Treatment Bench Book, followed by training, and has since extended this work to other branches of the justice and criminal justice system. So this has included revision of court and tribunal fact sheets on reasonable adjustments for neurodivergent court users. And Melanie is often asked to evaluate the impact of dyslexia, dyspraxia, etc. on court and tribunal users, preparing reasonable adjustments, documentations. Her guidance and resources are available on her website, which we will put into the chat room for people to have, and I'll do that now. So welcome, Melanie, and over to you.
Thank you, Miranda. Right, hello everybody. So just 2 more to go. I hope you're all bearing up. My session is just going to be concerned with the specific neurodevelopmental conditions. So I'm talking about dyslexia, dyspraxia, ADHD, dyscalculia, and the overlap with autism. And I presented quite a full set of slides. This is because I would like them to stand alone. And do take a look at the resources at the end. There's links from them. So as I bring it up, I've given as my title, there we are. And we're getting there. Slideshow from the beginning. There we are. Neurodiversity versus the courts. And this is because there really does seem to be an opposition between the skill set, the capabilities of ND people and the requirements, not only actually of the court and tribunal service, but of the whole criminal justice system. And when the two come together, it's very challenging. So what we're going to whiz through is an introduction, how I first got into all of this, impact of neurodivergence or neurodiversity. I see in the chat there's been a bit of conversation about language. I think I would agree with people who say that linguistically neurodivergent would seem to be the opposite of neurotypical, but I think the term neurodiversity is so much better known that we just want to stick with what's known, I think, on the whole. And then we've got the good practices. And the way I see it is very much tied in with a line in the Equal Treatment Bench Book. And I was really pleased when Penny mentioned this. I always worry that having got quite good definitions of these specific neurodiverse conditions in there, that nobody actually looks at it. So what they are talking about is, what do we need to facilitate reliable evidence? How can somebody be helped to participate in the criminal justice system? So here is somebody that we knew as Crisis John from the adult dyslexic dyspraxic group that I used to facilitate. He was arrested speeding along from Heysham Power Station where he worked. And when asked to blow into a breathalyzer, all he could do was actually perform the opposite and kind of gasp for breath. And so then it was not only speeding, but obstructing the police, which was a far more serious charge. And he was advised to plead guilty. But the more we thought about it, the more it was clear that this was not willful obstruction. This was actually a sort of stress reaction linked to his dyslexia and ADHD. And the stress had just got in the way of his complying with what the police were asking him to do. But what was even more of a shock, I suppose, was my first chance to see a neurodiverse person in the court. So instead of this very garrulous live wire, I found somebody who was just totally unable to function. He couldn't stay focused. He misunderstood the questions. He couldn't express himself. And he went quieter and quieter until he obviously was experiencing some sort of mental overload and shut down altogether. And right at the end, when the evidence and the witness statements that had been presented were actually moving things in our direction so that it was accepted that the stress and dyslexia caused this obstructive behaviour. There was suddenly a shifting argument, and I've come across this several times, where the Crown Prosecution Service was suddenly saying, well, hang on, if you're this disabled, should you be driving a car at all? And in fact, he had the advanced driver's course and was completely capable of driving a car. That wasn't what the issue was. So I suppose when you think about it, what are the attributes you need to perform or to function in a courtroom? Well, it's all these things that I've listed here. And if we look at each one of them, and then on the other side, we look at characteristics of neurodiversity or neurodivergence, we see that the exact opposite is going to be in the second column. And so I think this has been touched on earlier on today, but it just seemed to me, from seeing Crisis John to the many, many cases that I've been involved in since, that there is this opposition between the skill set of neurodiverse people and their capability and what the courts require. And I think this is partly to do with the whole way in which brains function of neurodiverse people. And again, we have to tell people that it's not linked to intelligence, it's not linked to race. Certainly the specific conditions are fairly heritable. And that another misunderstanding that we need to be ready for is that there's a thought that this is educational or medical. Once I was all ready to be an expert witness to somebody in the Crown Court, and the judge ruled that because I wasn't a doctor or a psychologist, I had no right of audience. And the fact that I was a tutor trained to do assessments and had actually written the guidelines in the equal treatment bench book for the judiciary, that didn't carry any weight at all. So impaired executive function, which I think might be covered tomorrow, I haven't heard it covered today, is again all these areas. And certainly these are all things that we need to sort of have at our fingertips in the criminal justice system in general. Flexibility in choosing strategies. I think if we think of one condition where inflexibility is the main characteristic, we would think of people with high functioning autism. And I remember the film The Lives of Others, where a Stasi trainer is running a training session, and he shows a little clip of a couple who are questioned, and they come out with the same words, word by word, their story is the same. And he says, they're guilty. They've just got a little text and they're repeating it all the time. I mean, ADHD is almost designed to get you into trouble. There's so many different ways, from risky behaviour, poor inhibition, and the way that professionals can get very exasperated with you if you're sort of fiddling around, looking all around the room, and it doesn't look like you're listening. It also looks like you're not taking the situation seriously. Especially true for those maybe without the hyperactivity who just lose concentration and drift off. I once had the chance to convene a little focus group who had experience of courts or tribunals one way or other. Quite a lot were actually the family courts or special needs tribunals. And I asked them what their problems were with this process. And these are the things that they came up with. So I'll give you a second to look at those. I think nothing particularly surprising there. But the one that did surprise me was this very clear expression that they felt they had to perform in a certain way. And if they weren't able to do that, they lost credibility. They didn't know quite how to perform, but they just knew they weren't performing as expected. And this is a slide I rather like, a judge asking somebody, have you lived in Manchester all your life? And the defendant says, not yet, hoping that his life is going to last a little bit longer. When I'm presenting training to people in various parts of the criminal justice system, I have a couple of slides that say why you need to know. And I think one is to do with the prevalence, and especially if it's the criminal justice system rather than just the justice system. There may be different studies showing different figures, but it's more than twice the general population are affected. So if you reckon that the particular study by the Learning and Skills Council and what was Dyslexia Action came up with 20%. So if you think a fifth of the people coming through your doors have got these difficulties. And I think the other reason people need to know is because behaviour can so often give rise to misleading impressions, and not only misleading, but impressions that that cause them to seem guilty. I mean, if you're inconsistent, it looks like you're untruthful. The number of times people are called evasive, but they've actually been unable to grasp the point of a question, the lack of eye contact, or you're being shifty. And sometimes when, we're going to talk in a minute about stress, but when somebody has just reached the end of what they can cope with and they've more or less shut down, you get questions like, you know, how can you run a business if you're this incapable? And sometimes the reaction to stress comes across as aggressive because people are struggling to such an extent. I always mention stress as a characteristic associated with neurodiversity because it seems to do two things. Firstly, it demolishes completely all your coping strategies, leaving you with nothing to draw on. But also, I do believe that there's a heightened susceptibility to stress. We know there is with autism, but I think this covers the full range of neurodiversity. And something interesting that Dr. Lolini brought out this morning is, supposing it's not only neurodiversity, but it's adverse childhood experiences where your behaviour is such that you are withdrawn, you don't engage with people, you don't engage with programs, you have a sort of trigger reaction to threat, and you may react aggressively to threat because of the experiences that you've been through. It was a very good example of somebody who attended a child custody hearing. He was representing himself because he couldn't get legal aid, and this is what he dictated to his wife about his experience. It's as though everything's kind of coming at him through a fog. And again, he's accused as being evasive and not keeping to his story because he's just all over the place. Something that I haven't heard mentioned today, but I haven't been in every session, is when we have people for whom English is not the first language, or people who are not very competent in English, that the behaviour or the difficulties that they are exhibiting are attributed to poor language skills. And this may be the case, but of course it may also be the situation that they're neurodivergent. They may not have been assessed, and there may be a stigma surrounding the whole issue of learning difficulties and learning differences in their country. So I think that's something to be aware of. This next case study is somebody who, although he was a Greek Cypriot, his English was perfect. I think he'd been in England most of his life, but his behaviour was quite extraordinary. This was a criminal case coming before the magistrates, and he was sort of like this. He was moving around like a windmill. He couldn't keep behind the little stand where he was meant to be. He had no control over his volume. He got very, very loud. Trying to follow what he said was more or less impossible. And when he got out his notes, he looked at them, he could make no sense of them, and he actually broke down and started weeping. The assessment that I'd done of him indicated that he was very heavily dyspraxic. And unfortunately, his case had involved driving under the influence. The test of sobriety was to do with bringing your finger to your nose and walking, putting one foot exactly in front of the other in a straight line. And there was no way he could do that under any circumstances. His dyspraxia made sure that he was unable to comply with these. So again, a robust argument had to be forwarded. Now, this is an interesting situation. Certainly, when I was last involved in the English and Welsh courts, you're not allowed to take technologies with you. And again, here's a chap, and his problem is that technology is not only his crutch, it's kind of him. He uses it for everything. And one of the questions he was asked, again, a child custody case, was his children's birthdays, and he just didn't remember them without looking at his phone. And they kept asking him compound questions. So he would, having poor short-term memory, he would remember the last bit and answer that. And by now he'd forgotten the first bit, and he was again accused of being deliberately confusing. And because he had no idea what had happened by the end, he asked if he could have a recording, but this was not allowed. So I think that this was an example of disability discrimination. And in fact, the next time I got a chance to revise the Equal Treatment Bench book, I mentioned two things. Firstly, that assessments can be done by appropriately trained tutors. You're not necessarily medical. And also that if somebody uses their technology, like a lame person would use crutches or a wheelchair, they need that technology to function, and that needs to be understood. So these people we've looked at, we've had Crisis John, who was unable to cope and shut down. We've had somebody so incapacitated by stress that he wasn't able to function. We have a man denied his technology who is confused himself and confuses the court, and then this character who's completely emotional, out of control. I was also very interested to read when Richard Branson was in court defending, or either launching maybe a libel case, that this man who's run all these companies, who's obviously extremely capable, was described as incompetent and tongue-tied. Again, he just couldn't manage the demands of the court. So let's have a look at the disability and human rights angle as we start to think about entitlements. I think, first of all, even nowadays, when you look at the websites of so many court and tribunal centres in this country, in England and Wales, and you look up either disability or reasonable adjustments, it is seen in terms of needing a wheelchair, a ramp, or a hearing loop. Aidan gave us a quick overview of the Equality Act. So here is the full definition of a person with a disability. It's always going to be long-term. It's certainly going to be substantial, usually by the time you've added stress in. So when providing documentation, I'm linking this definition and the entitlements that go along with the Equality Act to the person's assessment report. So one of the things in the Equality Act are these reasonable steps to change any provision, criterion or practice. And then finally, reasonable adjustments. And I think something I saw in the chat, which has certainly been my experience, is that the reasonable adjustments are all submitted to the right person in the right time frame, and darn me, the event happens and they're not in place, and it's as though nobody knows about them. So if you're involved in this type of work, you will need to chase them up, and you will need assurances that they are in place. Don't trust that they will be. We had a fantastic presentation by the Irish police with their whole organisation approach attached on, built around human rights. And I think it's worthwhile pointing out these two articles, the right to a fair hearing and the prohibition of discrimination. So this is another angle that we can come at things for those countries that have signed up to the Human Rights Act. As I said in my quick bio that was read out, I often end up providing documentation for the courts in support of reasonable adjustments. And one thing I look at is what assessment they already have. And it's often the case that they've been to university, they've got disabled students' allowances, they've got quite a good educational report, but this is nothing to do with their everyday life or their workplace. So often an updated assessment's needed. And the other thing that certainly won't be in any previous report is having a look at their difficulties related to neurodiversity and making some assessment as to how they would cope in the court. So the sort of documents that I've produced, and there's a link to a sort of template summarising previous assessments, pulling out what the main points are, and then highlighting the individual's difficulties that they would have in a hearing, and then what reasonable adjustments offset these difficulties. And I will usually flag up the guidance in the bench book. So it's very helpful in general terms if people know in advance what sort of issues will be covered. And this is all to do with the actual conduct of the court. So I'll just give you a minute to whiz through these. And what I would say to professionals is allow thinking time before you press for a response. Ask single questions, never compound questions, and reassure the client or the defendant, the witness, whoever it is, that if they haven't understood something, that they can ask for it to be rephrased or repeated without any sort of aspersions being caused. That they must, if any information is read out, that it's read out chunked with pauses in between so that the information can be absorbed. And also that it's helpful to check back to ensure somebody's understood without being too patronizing about it. But I suppose it's to do with the judge hopefully creating an atmosphere where the person feels that they can check back and ask for help if they need it. But of course, the key thing is, rather than trying to guess what people need, is asking them what will enable them to cope. And that's usually done in a sort of interview session with an ND specialist, just to work this through and talk it through. What do you feel you need? How long can you manage before your attention span has run out? And so this is a document that they have enabled, you have enabled, and that they have fed into, rather than somebody second guessing. I think one of the most helpful things of all is having somebody alongside you, especially for people who haven't got legal aid or who don't have legal representation. And the ND person needs to be aware that their helper has no right of audience on the whole, so won't be able to actually address the court, but they'll be very helpful in finding the place. You'll have been in sessions where they talk about, page 156, paragraph 3, subset 4, and then, the barristers, all the professionals, there they are, and the poor individual is thumbing desperately through this momentous, massive court document, trying to find their place. And so the helper is somebody that you can just get your head together with to say, have I understood this right, or did they mean something else? And also, if you are running out of steam, it's the helper who can remind you, I think you need a break now. So a very useful person to have alongside you. But again, something that must be negotiated in advance. I think we've had enough probably about whole organisational approaches today. So I can just move down, I think, to the very last issue, written communications. This is where I'm going to be talking about visual stress. Whatever session I'm doing, I always have a little slot on visual stress, because not only can it be remediated to some extent, but also it can be made very much worse by documentation that is unfriendly. So I will present professionals or organisations with a little chart that suggests what is helpful in written information, and all these things that are not helpful. I mean, one of the worst is when you justify the right-hand margin, so you've got a very neat-looking page, but what people so often say is, I just see this little white stream running right through it, and I can't read the words. Or when things are in capitals, whole blocks in capitals, that means that if you read by recognising words, it's taken that strategy completely away from you. So moving on to resources, I hope that people will take a chance to look at some of these. They very much complement the sort of things that we've already heard from people today. The first one that I produced was something for justice professionals, based very much on my experience of there being absolutely nothing in judicial guidance at all. And then, having done it, something for the justice professionals, I wanted to do the mirror opposite and do something for the people who were in courts themselves. Moving on. This is my little kiwi that I'm rather fond of. And this is a very basic information sheet that I was hoping might be circulated across the justice system, so that everybody had the same sort of information. Kiwi standing for key facts, impact of the specific learning difference, so neurodiversity, ways of working, and further information. There's a version for young people as well. There's something particularly for prisons following the recent reforms. And then briefing for lawyers. So I think that is the one that's probably most relevant for this session, produced for the Law Society, when finally, after about 10 years, I managed to find somebody who would correspond with me. And let's mention this equal treatment bench book. Right at the end is a disability glossary, Appendix B, and there you'll find within the alphabetical listing the neurodiverse conditions, but also within the bench book there are very useful sections on disability in general, physical disability, mental disability, and just good practice ways of working. I worry that magistrates especially have got so much with new sentencing guidelines, this, that and the other, that they don't give this book, the attention it deserves, and they don't consult it as often as they might. But at least having guidance there it is obviously useful. So a couple of thoughts to finish off with. I very much agree with something in an earlier edition of the Bench book, that we're not so much trying to get a list of all these conditions and try and tick box people and match them with the conditions. What we're trying to do is decide if somebody is unable to cope, what accommodations need to be made. This Judge Gordon Ashton was the man I worked with in the Equal Treatment Advisory Committee. And what he was saying was justice, everybody needs to have access to justice. So I think starting with the issue of vulnerability, is this person vulnerable? If so, what do they need to be able to access justice on the same footing as everybody else? So I think I've got a few minutes for questions.
You do.
I'll stop there and I will stop share. Right, there we go.
So if you just bear with me 1 second.
Yes, I have a chance to look at the chat obviously while I was talking. So
yeah.
Out.
Melanie, any comments or experience reopening, adjourning cases, etc., with neurodiversity, stroke, mental health condition being acknowledged or diagnosed after the court? As it was mentioned, many people are ashamed of it, scared of authorities, don't know it plays a role, and are not diagnosed yet.
Well, I think this depends on something I didn't really get a chance to mention, and that was establishing a relationship with the lawyer. This is, I mean, obviously, if somebody has a solicitor, they have the standing to make these sort of interventions. Whereas if you're simply an expert witness, you often don't have the footing to do so. When things have gone wrong, there is a whole raft of ways of complaining, whether it's the administration of the court, whether it's a lawyer, whether it's a judge, whether it's a magistrate. But that is, you sort of don't want to go there, do you? If you simply want to open it, I would do it through the lawyer. And if there isn't a lawyer, you'll always find that there is a correspondence email to the court. You would just have to try writing to them, but it may be that you simply don't have the standing, unfortunately, to do that unless the person is lawyered up.
I think you've kind of raised some very interesting areas around the court and the reasonable adjustments, and your reference to the equal treatment bench book. But what do people do when they go down the right road? They do write to the judge, they request the reasonable adjustments, they put it into writing, they refer to the equal treatment bench book, and they are still denied adjustments. What would people do in that situation?
Well, I think the day when you check that they're there, and then the day before you check that they're there again. So I suppose what that means, if they're not there, at least you will know they're not there. And I think the first thing that the individual would need to do would be say, I have a disability according to the Equality Act. I'm entitled for reasonable adjustments. I feel that I'm unable to participate in this hearing unless I have them. It's hard to be that firm, but you're standing on legislation. You're actually, in this country anyway, you're standing on the Equality Act. Maybe in other countries you can stand on the articles from the European Convention on Human Rights, but you need to stand on something. I think if you're not standing on anything, it's not going to work.
Yes. I think you've raised some really interesting insights into neurodivergent persons' experience of the court system. I liked the way you reinforced that neurodiversity is not linked to race or kind of intelligence, and you've kind of brought out around executive functions that need to be better understood. in this kind of environment. And you drew on Richard Branson, described as being incompetent and tongue-tied, and yet an incredibly successful business person, entrepreneur in the world. And somebody like Richard Branson, who struggles in court, I think it just gives a really great reflection of some of the vulnerable people who end up in court, whether as defendants or witnesses, just how difficult it can be for them to navigate and be able to present under the kind of guise of courts and the stress that can cause. There were some other comments in the chat, some valuable comments. Just one was in some places in the UK, there are now more women diagnosed with ADHD and ASD than men, which is interesting. And something else you touched on about the importance to understand neurodiversity is present in people of all nationalities. And again, that resonated with me as a social worker. I work with unaccompanied asylum-seeking young people where I identify neurodiversity traits, but they're not taken seriously as it's felt it's a language and cultural barrier. So I think a lot of work to be done to overcome them areas. But thank you so much, Melanie, for such a wonderful presentation, really insightful, lots of information. So thank you very much.